Hello everyone, welcome to Court with Krissy and Licking County Municipal Court, where you can't rewind. But don't worry, I joined this jury trial just in time. What did you miss? You missed the jury selection, opening statements, and testimony of one of the troopers. But we kick it off just as the defendant starts to refuse sobriety test. After all, you can't expect him to know his ABCs when he dropped out of school in the 9th grade. The charges: OVI, no seatbelt, no license, and driving reckless. The jury gets to decide on the OVI while Judge Stansbury rules on the rest. It's good. I hope you like it. Court with Krissy is now in session.
You don't think you'd be able to do it?
I usually have knee problems, but like I said, I could try, but I've never been good at it.
I'm just asking if you think you could do it.
No, I wouldn't prefer doing it because I never really.
You don't want to do it?
I've never been good at straight line.
Okay, you don't want to do it?
You know what I mean?
I'm just asking, you don't want to do it?
I mean, I don't know. Like I said, I don't want to just.
Would you be able to stand on one leg?
I'm not good at. That's what I'm saying. I'm not good at balancing. Like I said, I've never been walking like.
What I'm gonna have you do is, do you know your alphabet fairly well?
My alphabet? I never really do my alphabet, but I can count down.
You know the alphabet though, from A to Z, right? It's yes or no.
I never.
You don't know the alphabet?
No, I never went to really. I dropped out at 9th grade.
All right. So you can't do the alphabet. You don't think you could?
I mean, I can walk a straight line for you. Like I said, I'm not really good at it. Like I said, I've never done it really.
You've never walked in a straight line before?
No, I'm not really good at it. I never. Like I said, I tried to do a straight line. I never did it really good at it. Or, like I said, I never really had any problems with it before. Like I said, I've never had really any problems with it. Like I said, I never had no issues. But like I said, I didn't really finish school.
So, because you didn't finish school, you don't think you can walk in a straight line?
I mean, I could try to walk in a straight line, but
I'm asking if you think you can do it. That's all I'm trying to get at.
I never, like, I'm not good at walking in a straight line. Like I said, I'm not really good at it.
Trent, I can't force you to do this, okay?
Right.
If you think you can do it, we're going to try it. If you don't think you can do it, then we're not.
Right, I just don't want to, like prove, like, that I'm retarded. I'm trying to prove you something wrong. Like I said, I know. Like I said, I'm trying to tell you the truth.
So yes or no?
What? The walk in a straight line. Is there anything else that
that alphabet or stand on one leg?
Huh?
Alphabet or stand on one leg?
Alphabet or stand on one leg?
Right there, turn face in front of my vehicle for me.
During that interaction there, was there anything about his demeanor, behavior, or speech patterns that you noticed?
He was stumbling on his words. One time he was saying he couldn't walk on a state line. Was rambling, said the same thing about 8 different ways. Again, strong odor of alcohol beverage on his breath.
According to your training, can that be characteristics of impairment due to alcohol consumption?
Yes.
Can you determine if someone is impaired due to alcohol with only one field sobriety test?
Yes.
And what about with only one field sobriety test and no chemical test?
Yes.
Have you ever seen a case where all possible clues of impairment as provided by NHTSA?
Objection, Your Honor. By asking a hypothetical.
Come on up. All right, objection will be overruled. You may continue, Ms. Yeager.
As I was saying, for cats, according to NHTSA, there are several different clues of impairment. Have you ever seen a suspect display every single one that's been in there?
Yes.
Is that something you frequently see, rarely see? I
Quite
mean, outside
rarely.
of standard field sobriety and everything.
Quite rarely do we see everything displayed.
And did the defendant exhibit all possible clues of impairment in this case?
Yes.
And based on your training, experience, and observations, do you believe that the defendant did consume alcoholic beverages prior to driving?
Yes.
Okay. And do you believe that he drank alcohol to the degree that it impacted his ability to properly and safely operate a motor vehicle?
I'm sorry, one more time.
Do you believe he drank alcohol to a degree that it impacted his ability to properly and safely operate a motor vehicle?
Yes.
Do you believe that he was impaired due to alcohol consumption on that date?
Yes.
Based on that investigation, what did you do next?
At this point in time, with everything I've gathered throughout the stop, I instructed him to walk to the front of my cruiser, where I placed him under arrest for OVI.
Okay. And so when you place him under arrest for OVI, what is it that you're considering to say, hey, this person's impaired, I'm placing him under arrest? What did you, specifically for the defendant here?
I instructed him that he's going to be under arrest for operating the vehicle while impaired. He was handcuffed, read his rights, and search power to be placed in the back of my car.
Okay. And then what did you base your decision to arrest on? What circumstances?
Everything from the vehicle in motion to the personal contact, field sobriety test.
Okay, to someone who has no idea what you just said.
So it was everything from the beginning of the stop till where we wound up here. So it was the high rate of speed, the abrupt stopping prior to making contact, which thankfully he did make contact with the commercial trailer. The slow pulling over onto the shoulder where he was straddling the fog line for some time before making his way all the way to the shoulder to come to a stop. The slurred speech, HGN, VGN, the strong odor, the diminished fine motor skills, the slow and lethargic movements. So the totality of everything I've conducted so far in this traffic investigation.
And you did a search incident arrest?
Yes.
Find anything of note?
No, we finally found his, I think, social security card, and we were able to properly identify him.
Okay.
Yes, sir.
Okay, place your hands behind your back, palms together like you were clapping.
Can I see him there?
At this point in time, I'm going to be placing you, don't step on me.
Sorry.
I'm going to be placing you under arrest for operating the vehicle while impaired. I'm going to read you your rights. You have the right to remain silent. Anything said can move against you in court. You have the right to an attorney. If you cannot afford one, won't be appointed to you at no cost.
Can I walk in a straight line?
For that right now, Trent.
You can answer my questions now or any time and stop till you talk to your lawyer and have a lawyer present with you during the questioning.
Too late.
What do you mean?
Do you understand these rights that I read to you, Trent?
Can I walk in a straight line?
We're past that.
No.
Do you understand these rights I read to you, Trent?
Can I walk in a straight line?
No, sir. We're past that point now, okay?
I've already offered that to you too many times.
Yeah, I was asking that. I walk in a straight line or after better order.
I want to 19. I'm trying to find an ID card. Name date for you.
Here's a social.
Trent, what is your social? You don't know your social? Okay, how you spell your name?
T-R-E-N-T-N.
T-N?
Yeah.
Spell it again.
I'm sorry, how was he spelling that?
TRENTN.
T-R-E-N-T-N.
T-N?
Yeah.
There's an N at
Come
your
here.
name.
Stand right here.
Go for it.
T-R-E-N-T-N. Or, so I can't walk in a straight line or?
Trent, is that how you spell?
Yeah.
Okay, how you spell your last name?
McCoy. M-C-C-O-Y.
O-I?
Why?
M-C-C-O-Y.
Okay. What's your date of birth?
Just June 22nd, 2015.
Okay. There's nothing in our system with that name and date of birth, okay?
Well, I mean, that's what I need.
Do you have an ID card or something?
Come here. Let me make sure you don't have anything else on you.
Why can't I walk in a line
Okay,
already?
we're past that now, okay? You are being placed under arrest for FBI, okay? The speed you were going was very dangerous, okay? You put yourself and other people's lives in danger.
That's all.
You're what?
I was just getting over it.
Getting over. You're going 127 miles per hour. I initially checked with my laser going 100
Speaking of which,
miles.
you want to go get that on my ring?
I got on.
You got on yours?
Okay.
Why can't I walk in a straight line? Or?
Because we're past that point now, okay? Yes. You should have said yes when Trooper Cat's here. okay? I have to identify who you are, okay, Trent? With that name and date of birth, okay? You do not know your social at all? Right there, right there.
My social security card's in there.
Okay.
Face front over. I am going to ask you though, dude, because that alcohol is reeks coming off your breath. How much have you had to drink tonight?
I told you, I only had, like I said, I really had nothing to drink tonight.
Really had nothing to drink tonight?
Yeah, I only had like nothing really to drink.
Just a little bit? What's a little bit? 'Cause you can barely stand up right now.
Yeah, actually I can. Like I said, I was trying to walk a straight line. Like I said, you wouldn't even let me do that.
Go ahead and separate your feet, man. Trent, walk over here with me.
Can I actually talk to my girlfriend?
Over now. Back in my car. Rare.
I can't even tell my girlfriend anything.
Nope, not right now. Go ahead.
So I can't even talk to her?
No.
So now you said you placed him under arrest, read him his rights, searched, placed him in the cruiser. What happens next?
So now I'm gonna go and talk to his girlfriend, and we're gonna try and figure out what we're gonna do with her in the vehicle.
Okay. So after you get that situated, do you start your citation and paperwork on scene?
Yes.
And did you advise the defendant of consequences of taking and not taking a chemical test?
Yes.
Your Honor, may I approach?
You may.
I'm showing you what's marked as Plaintiff's Exhibit 4. What is that today?
This is the Ohio BMV 2255.
Okay. And is that the form that you completed and read to the defendant?
Yes.
Okay. What is the purpose of that form?
So the purpose of this form is to basically notify them of the penalties if the test over or if they refuse said test.
Does it also explain what happens if you take a test and it's under the limit?
Right. So if they test under, there's going to be no immediate ALS suspension.
And then if they test over the limit, what would the suspension?
So with it being a first-time offense, if he were to have tested over, it's a 90-day suspension on the license, and it only increases for if they have any priors, which he did. But if you were to have tested over, it's a 90-day suspension. If you refuse on a first-time offense, it's an automatic 1-year license suspension.
Okay. And so did you ask him if he had ever been arrested for an OVI before?
I didn't recall if I asked him that.
But you did read him the applicable portions of that form?
Yes.
And who witnessed you doing that?
Trooper Kastner.
Okay. Is that true and accurate copy of the form other than being 2 pages instead of, a front and back of the form you read to the defendant on March 7th, 2024?
Yes.
All right. And did he agree to submit to a breath test?
He refused.
I saw that. Substance. Vehicle under the influence of alcohol. Alright, Trent, I gotta read this form to you, okay? You're not under arrest for operating the vehicle under the influence of alcohol, drug, or a combination of them. Right here. Operating the vehicle while under the influence of illicit controlled substance or illicit metabolite of a controlled substance. Operating the vehicle after underage alcohol consumption or having physical control of a vehicle while under the influence. If you refuse to take any chemical test required by law, your Ohio driving privileges will be suspended immediately, and you have to pay a fee to have the privileges reinstated. If you have a prior conviction of OVI or operating a vehicle while under the influence of illicit controlled substance or illicit metabolite of a controlled substance under state or municipal law within the preceding 20 years, now under arrest for state OVI. And if you refuse to take a chemical test, you'll face increased penalties if you subsequently are convicted of the state OVI. If you take any chemical test required by law and are found to be at or over the prohibited amount of alcohol, controlled substance, or a metabolite of a controlled substance in your whole blood, serum, or plasma, breath, or urine set by law, your Ohio driving privileges will be suspended immediately, and you have to pay a fee to have the privileges reinstated. If you take a chemical test, you may have an independent chemical test taken at your own expense. Okay, so I'm going to offer you a breath test. You've been arrested for OVI before?
Yeah, no.
Yeah, no?
No.
Okay. If you have no priors and you blow out or over the legal limit, it's a 90-day license suspension. You don't have a license. But it's a 90-day suspension in the state of Ohio, okay? If you refuse to breath test with no priors, I'm off you tonight. It's an automatic 1-year suspension. Okay?
So if I refuse no breath test, it's what?
If you refuse, it's a 1-year suspension
1-year suspension of what?
to drive.
Okay.
Which you can't even drive anyways. You don't have a license. You're not even valid.
Right.
It would just hurt him if he wanted to get one.
Oh, yeah.
But like I said, I didn't offer to do a fucking driver test. Like I said, your guys arresting me for no reason.
Okay. Well, if you think there's no reason, then we'll figure this out in court then. It stinks like a freaking brewery back here. Your eyes are bouncing all over the place. Your pupils are dilated. Eyes are red glassy bloodshot. You're unsteady on your feet. Strong odor of an alcoholic beverage coming off your breath. You admitted to drinking. There's an open can in the car. You're doing 127 down the interstate. Did I miss anything?
Actually, yeah, because that it was not mine.
The what?
The open container was not mine.
So are you going to give a breath test or no?
No.
So now that you read him the 2255, what did you do after this?
After this, again, we got the car and passenger situation taken care of. Where afterwards I transported him to the Lincoln County Justice Center.
Okay. And you cruiser have a backseat camera?
Yes.
And was it working properly that day?
Yes.
And at some point, did you review the recording of the backseat camera?
Yes.
Okay. When you did that, did you notice anything that caused you concern in this case?
He, fairly shortly after, while on the route to the jail, he passed out in the back seat.
Okay. And Your Honor, now I am switching to what is labeled rear cam on the flash drive that is Plaintiff's Exhibit 1.
Very well.
And just to be clear, is this the cage cam from that day?
Yes.
Okay. And do you have the ability to alter this in any way?
No.
What is that noise that we're hearing?
That's Mr. McCoy snoring in the back seat.
Does he ultimately, at some point, wake back up?
Yes.
Okay. And does he stay awake or fall asleep again?
Falls back asleep.
buckle in people that are handcuffed in your back seat?
Yes.
So was Mr. McCoy seatbelt on when you started driving to the Justice Center?
Yes.
So when you arrived at the jail, do you recall if he was awake or asleep?
When we got to the jail, he was awake.
And did you ask him again about a breath test?
Yes.
No.
Yep. Hey there, OSP. I got one male OVI. He is cooperative. Thank you.
Who did you just announce yourself to?
That was for the deputies at the jail. I'm at the Solly Port. All right, Trent, you gonna give me a breath test or a chemical test?
What?
Are you gonna give me a chemical test?
What's that?
The test I offered you?
I still don't know what that is.
Well, I offered you the breath test, and you told me no. Is your answer still gonna be no?
Yeah, I tried to do the walk test. You did offer me no.
Yeah, I'm not even asking about that. I'm asking about the test.
The breath test?
Yes.
No.
You don't want to do it?
No.
Okay.
So, based on that, what did you mark on the BMV 2255?
Refusal.
Okay. And what time did you mark for refusal?
The time I put for refusal, don't recall. It was time stamped in the CAD, but I do not recall what time I put it as refusal.
Did you put the time, the first no, or did you put the one at the jail?
I believe I put the time once I offered it to him the second time.
Okay.
Which
And
would
so
be
what
at the
time is it
jail.
on the video?
4:18, so 4:18.
So a little over an hour after you initially stopped him?
Correct.
Okay. Did you ultimately issue a citation to the defendant?
Yes.
And what did you issue him a citation for?
It's going to be for the breathless operation, no OVI, and seatbelt.
The portions of the various videos that we have seen here today, are those a fair and accurate depiction of your observations and interactions with the defendant on March 7th of 2024?
Yes.
Thank you. Nothing further at this time, sir.
All right, cross-examination by the defense.
Thank you, Your Honor. Good afternoon, Trooper.
Afternoon.
My name's Lisa Tome. I think we've met.
Yes.
Okay, so I want to go back to your training a little bit. You indicated, I think, a couple times throughout your direct testimony that you talk about phases of OVI detection, and the first phase is the vehicle in motion.
Right.
And that's where you're observing somebody driving their car.
Right.
And there's numerous things you would look for to sort of raise a red flag as to whether or not the person should be pulled over and maybe ultimately tested for DUI, correct? OVI.
Right.
Numerous things you would look for. Certainly swerving,
Yeah, that's something that we look for.
and I'm sure there's times where you see people committing numerous marked lanes violations.
Right.
Of course, would be a traffic accident.
Mhm.
Okay. And in this case, what brought your attention to Mr. McCoy was high rate of speed.
Correct.
Okay. And you indicated on direct that you noticed some weaving.
Right.
Okay. And that weaving was within his lane of travel, correct?
Correct.
So he didn't cross the double yellow line or the fog line.
He did not drive marked lanes, but he was
Okay.
moving.
Didn't commit any marked lanes, weaved within his own lane, driving super fast.
Right.
Okay. Now, when you pull him over, you approach the passenger side.
Correct.
So you're engaging in a discussion with he and his passenger, who's his girlfriend.
Right.
And you learn through that discussion that they had had an emotional day. They both indicate that he had been crying.
Right.
And so this would be when you start your second phase, personal contact, right? Okay, so your personal contact, well, first it's sort of at a distance because you're on the passenger side.
Right.
And you indicated that he was lethargic, diminished fine motor skills. He's seated in the driver's seat during this whole time, though, right?
Right.
And because he didn't have a driver's license, normally you would ask for somebody to get their driver's license out of their wallet and hand it to you, and you'd be looking for clues at that point, right?
Right.
Like, did they fumble? Did they hand me a credit card instead of a driver's license? We don't have that here in this case, correct?
Well, he was struggling to even point at the speedometer when he tried to explain to
Okay,
me the reason for
okay.
the speed.
So we don't have the usual handing of the driver's license, opening of the
There
wallet.
was no transfer of documents.
Right, because he didn't have one.
No.
So when you say diminished fine motor skills, you're talking about him pointing to his speedometer.
Correct.
Okay. Now, they also indicated to you that they had been at the Flying J/Denny's, correct?
Correct.
Okay. And you know where that is?
Yes.
Okay. And that's the Kirkersville exit, I believe?
Yeah, right there
Okay.
on 158.
And they further indicated to you that they were driving to Reynoldsburg?
Yes.
Okay. So he was headed from the right direction to the right direction. Is that fair?
Correct.
Okay, so if he had left Denny's and was headed to Reynoldsburg, then he would be where you stopped him. Okay. And of course, I think the Denny's is probably a truck stop, 24-hour restaurant.
it is 24/7,
If you
I
know,
believe, yeah.
okay. Because it's 3 a.m, so, okay. So no red flags based on that information. Okay, so then, based on your conversation, you asked him to get out of the vehicle, correct?
Yes.
Okay, and he opens the door and steps out. I think you indicated he was unsteady on his feet at that point,
Yes.
certainly didn't fall down.
Somebody doesn't have to fall down to be unsteady.
No, but he didn't fall down.
He didn't fall down, but he was
Okay.
still unsteady.
Okay. He didn't require your assistance to get out of the vehicle?
No, he got out on his own.
Okay. And he put his hazards on, correct?
I don't recall. I guess
Okay.
he did. I don't recall.
If I said we could see on the video that his hazards were on while you were doing field tests, would you agree with that?
If they're on in the video, then yeah, I
Okay,
agree.
you don't remember it just from, okay. All right, so your initial then, after he gets out of the vehicle, is to discuss field sobriety tests with him.
Correct.
Okay, and you always give the horizontal gaze nystagmus first?
Yes.
Okay. Now, of course, nystagmus is something that can be caused by things other than alcohol, correct?
It can be. Yeah.
Okay. And sometimes in some people it occurs naturally, correct?
That is correct.
Okay. So while you were administering this test, you indicated that you saw some clues. Well, I saw all the clues. And we can't really see that on the body cam, correct?
Actually, you might be able to see that if we zoom in on the face. You could probably see the eyes bouncing on the body cam.
Okay. Okay, but that's not what we saw
Well, we didn't
previously,
see it on the face.
earlier today. Okay. So while you're doing that, he follows your pen. He follows the directions. I think you said he understood the directions, correct?
Yep.
And you didn't have to repeat them.
No.
And he followed what you asked.
Right.
When you said follow here, he followed there, he followed here. Okay.
Correct.
And I believe you said there was a lot of swaying during that?
He was swaying from side to side. forward,
Okay.
backward.
Do
I'm
you,
not saying he was heavily swaying as to the point where he was going to be off balance and fall
Okay,
over,
sure.
but he was swaying in position.
okay. He kept his arms down at his side the whole time?
Correct.
And when you asked him to do something, he answered, yes, sir?
Correct.
And you were able to understand all of that, right, when he was talking to you?
I was able to understand him, yes.
Okay, all right. Now, with regard to the walking a straight line, he says, I've never been good at it. Now, you did, and ordinarily, if someone's going to perform it, you would demonstrate it, correct?
Correct.
And I understand that you didn't hear because you never really got to that point, correct?
I never got confirmation if he's going to do it or not.
Okay, so when he's saying, I've never been good at it, you hadn't already shown him what he was supposed to do.
I mean, it's walking on a straight line.
Right, but it's not a balance beam,
I'm not asking him to be elevated off the platform.
right? But he wouldn't necessarily have known that based on what you asked him to do, correct?
To walk the straight
Calls
line.
for speculation as to what the trooper
Okay.
thinks he
I'll
knows.
sustain the objection.
Okay.
Sure, disregard the last question.
You asked him to walk a straight line, but did not demonstrate that.
He would not acknowledge if he was going to take it or not.
Okay, so there was no
So we
need
never
for you
got
to
that
demonstrate.
position to
Okay,
demonstrate.
okay. And he also indicated to you that he had some knee problems.
Right.
So, and that was in response to your medical questions.
Correct.
So you asked him about the ear infection, no. Vertigo, he didn't know what it was. And with regard to any leg issues, he told you he said he had previously been in a vehicle accident.
Correct.
Okay. And you certainly understood what he was saying, and that there were some knee problems as a result.
Correct.
Okay. So, now I'm going to cut ahead a little bit here just so I don't forget. There was some discussion of a spiked tea can.
Yes.
Okay. And you believe that was old.
I never said that. I just didn't know if it was fresh or not. I never actually retrieved the can. I didn't feel if it was hot or cold.
You don't recall having a discussion with Trooper Casimir
I
that
might have
you
said it
believed
could
it was
be fairly
old?
old, but again, I wasn't too concerned about one empty can in the back.
Okay. Can I have a moment, Your Honor?
You may.
Can we approach, Your Honor?
Yes. All right. Ladies and gentlemen, technical issues for the moment. So we're going to take a brief recess, about 5 minutes. It's about 21 after now. Let's just make it even 2:30. I want to remind you not to discuss this case among yourselves or permit anyone to discuss the case in your presence. Remember that if anybody asks you about the case, you tell them that the judge said you're not allowed to tell them anything about it, including what type of a case that it is. And I would remind you that it's your sworn duty not to form any opinion on this case until it's finally been submitted to you. So we'll reconvene at 2:30. Court will stand in recess.
All right.
Are you able to locate that?
Yes, Your Honor.
And is the defense ready to continue with its cross-examination of the witness?
Yes, sir.
And Ms. Jaeger, are you ready to keep going?
Yes, Your Honor.
All right, let's bring in the jury.
All rise for the jury.
All right, please be seated and let the record reflect that the jury is now returned into the courtroom and all 9 are seated in the jury box. Ms. Tome, you may continue with your cross-examination of the witness.
Thank you, Your Honor. Okay, Trooper, so we were talking about the can that was in the back of the car, and you indicated you didn't recall making any comment on it being fresh or old, or you remember that? Okay.
Right.
So I'm going to direct your attention to your body cam.
I didn't get the exact name, but it was a spiked drink in the back. It was a can.
I saw it back there. It looked old, but yeah, it was. There was an empty can there. I know.
Okay, so you indicated that you saw the can and it looked old. Okay, and you just forgot that you had said that, or,
Right.
okay. Now, Bobby, you can close that down or whatever you need to do. Okay, so now I have to get back to where I was, sorry. All right, so he didn't do any further tests, and at that point you arrest him.
Correct.
And you were, once he's arrested, he indicates to you that he would like to go back and try that to walk the line, right? He said that, and you said it's too late.
Yes.
Okay, and he sort of asked repeatedly, can I please try to walk the line now? Okay. Now, when you are trying to get his information, you misunderstood the spelling of his name, correct?
I mean, that's what we heard him say. That's how he spelled it.
Okay, so, and what he said was Trenten?
We heard, or I heard Trentn.
Okay, you just heard TN.
TN.
All right. Fair to say that to say T and E back to back, the E kind of gets lost.
I guess if you're slurring your words, maybe.
Okay, fair enough. But there is, in fact, the same hard vowel sound at the end of T and E. T-N. T-E, you could say T-E-N, T-E-N.
I suppose so.
Okay. So he was arrested and put in the back of your cruiser, and again, this is at this point like 4 a.m, right?
Right.
Okay. So you indicated he, quote, passed out. Now, he didn't faint or in any way like lose some sort of consciousness, correct?
Right. Well,
He fell asleep. He fell asleep. Okay. And he fell asleep, he's snoring, and when you mention his name, he wakes up and he communicates with you, correct?
Right.
Okay. And this happened between Kirkersville and I guess it would be Pataskala would be the next exit if you're going west on 70, where he was put in your cruiser at, where he was arrested.
So where we were stopped is what the 113. So yeah, Etna Township area is where we were
Okay,
at.
so close to the Etna Pataskala exit 70 west.
Yeah, so the Pataskala exit, so for 310 would be about 5 miles east of us where we were at.
East. So he was past Pataskala.
Right, so we were coming up into Reynoldsburg. We were
Right,
still in
right,
Etna
that's right,
Township.
because he said he was going to Reynoldsburg.
Right.
Okay, so 5 miles past the Pataskala exit, back to the Licking County Justice Center. I mean, we didn't watch the whole thing, but it's probably at least half an hour, isn't it?
Yeah, about
Okay.
20, 30 minutes.
And again, it wasn't necessary that he go to jail, correct?
That's up to my discretion.
Right, it is up to your discretion. In this
Right.
case, you chose to take him to jail.
I chose to take him to jail because he's doing 57 over.
Okay, you
while
chose to take him to jail?
impaired
Okay.
With a pregnant 18-year-old in the passenger seat.
Okay.
Putting many lives at risk, so yes.
Okay. And with regard to the 57 over, you cited him for reckless operation for that? Okay.
Yes.
And you could have cited him for speeding, but when it was that excessive, you chose to charge him with a slightly more egregious speeding offense? Okay. Can I have a moment, Your Honor?
You may.
I have no further questions. Thank you, Trooper.
All right, redirect examination, Ms. Yeager.
Yes, thank you, Your Honor. Bless you. Trooper Caps. I'm going to kind of go all over the place here, so bear with me. Ms. Tome was asking you on cross about the speed and the reckless operation citation. Did you cite him for reckless operations solely because of how fast he was going?
Not just for the speed alone, no.
What else was in consideration for
was
the
the-
reckless operation charge?
It was the higher rate of speed, the abrupt stopping, the slow to move over, no seatbelt. He's got passengers in the car, and he's recklessly operating the vehicle on the interstate.
Now, is that type of driving, or those crash-causing events in your experience?
Objection.
Yes.
Basis?
Yeah, speculation. I cited him for reckless operation. I don't think.
I think there needs to be a bit of a foundation laid there, so I'll sustain the objection.
So, when someone is driving at a higher rate of speed, does that increase the risk of serious harm versus minor harm if there is a crash?
Yes.
Okay. Does the risk of accident go up also with the increase of speed?
Yes.
When you were speaking with the, when you did speak with the passenger, did you notice an odor of alcoholic beverage coming from her?
Not from her, no.
When you approached the vehicle and spoke with the defendant passenger, was there any indication of an emergency?
No.
Was anybody bleeding, screaming?
No.
No. Nobody said there was an emergency?
Nope.
Okay. And we talked a little bit on cross too about nystagmus. And you said it is present on your body cam.
Yes.
I'm going to play, maybe, once I find it. I'm going to play a clip and then I'm going to...
Yes, sir.
Okay, keep him right there for me.
Just raise your hand to stop when you see nystagmus on the video, okay? Right there? Okay. So this would be why he is looking to his left?
This is when he's looking to his left, I'm going to the right. And when you see the stimulus get out to the corner of his eye, you will see his eye start to bounce as it attempts to maintain contact with the stimulus. And you can, if you need to zoom in on that too, you can really, but it's, you can see it on his left eye. Again.
Right there? So you just pointed out at least two spots that you saw it on the video?
Yes.
I'm not going to go through the rest of that. When talking with the other field sobriety tests, can refusal of field sobriety tests be a clue of impairment?
Yes.
Nothing further for Troop Capture.
Recross?
No, thank you.
All right, Trooper, you may step down, thank you.
Thanks, sir.
All right, any additional witnesses on behalf of the state?
Can I have just 1 second?
Yes, you may.
Your Honor, I would like to briefly recall Trooper Casimir.
Very well. Is he in the witness room?
He's in the witness room. Find it later.
All right, Trooper, if you'll please approach the witness stand and retake your seat. It's not necessary for you to be re-sworn, but I would remind you, sir, that you remain under oath.
Yes, Your
You may inquire.
Thank you. Trooper Casimir, do you recall with the stop with Mr. McCoy that you had some difficulty identifying him because he didn't have a license or an ID on him?
Yes.
Okay. When you asked him what his name was and you asked him to spell it, what did he spell?
He said Tretn. It was very difficult when hearing that from that T-E-N. Initially, I even had to tell him multiple times, can you respell that? And even I had to confirm it on my paper after I wrote it down.
So when you wrote it down, did you write down T-R-E-N-T-N? Or did you have a vowel in between the T and the N and show it to him?
I'm not 100% sure, and I don't want to give an inaccurate answer.
Do you remember writing it down and showing it to him?
Yes, and he did confirm it.
And he said how you had it written down was that
Yes.
was correct? Okay. Whose camera am I on? Thank you.
Are you the resident of the vehicle? If you think you can do it. Yeah, I'll. Anything you say can move against you in court. You have the right to an attorney. You cannot afford one.
I walk in a straight line.
It's too late for that right now, Trent.
Answer my question now anytime and stop your lawyer and have a lawyer.
Can I walk in a straight line?
Too late.
What do you mean it's too late?
Too
You
late.
understand
We're
these
at
rights
this
I
point
read
now.
to you, Trent?
Can I walk in a straight line?
No.
Cross that.
No.
Why?
Understand these rights I read to you, Trent?
Can I walk in a straight line?
No, sir. We're past that point now, okay?
I've already offered that to you too many times.
Yeah, I was
One
asking
second,
if
sir.
I walk in a straight line or half a better walk. One halfway.
151, secure 19. Trying to find an ID card or name, date of birth for you.
Okay.
Trent, what is your social?
I don't really know.
You don't know your social?
No, sir.
Okay, how you spell your name?
T-R-E-N-T-N.
T-N?
Yeah.
Spell it again.
Trent. T-R-E-N-T-N.
T-N?
Yeah.
There's an N at your name.
Stand right here.
Spell it for me.
T-R-E-N-T-L.
T-R-E.
So I can't walk in a straight line or?
Trent, is that how you spell it?
Yeah.
Okay, how you spell your last name?
McCoy. M-C-C-O.
So do you recall what you wrote down and showed him?
Yeah, objection asked and answered.
Actually, it wasn't answered.
I don't believe he was asked if he remembers what he wrote down, so you can answer that question if you remember how you spelled it on that piece of paper.
Yes, Your Honor. I did E-N-E, or E-O-N.
T-R-E-N-T-E-O-N?
Yes.
Okay. And
Because
however you were,
as it saw in the video, I had to ask him multiple times as he was learning his speech. He was combining letters together. I don't even think he thoroughly knew how to
Objection to
spell
what
himself.
he thought.
Well, I'll sustain the objection as to the speculation as to what the defendant was thinking, but the rest of the answer can come in.
Nothing further, Your Honor.
All right. Recross, or actually, it's just cross.
No, sir.
All right, very well. Trooper, you may step down.
Thank you, Your Honor.
Any additional witnesses on behalf of the state?
No, Your Honor.
Counsel approach. Gentlemen, well, I'm sorry. Ms. Yeager, did you wish to address your exhibits?
Yes, Your Honor. The state would move to enter into evidence Exhibits 1, 2, 3, and 4.
And just for purposes of the record, I have those as being written on a piece of paper I can't find. There we go. Number 1 was the flash drive with the various video feeds. 2 is the photograph of the speed measuring device. 3 was a certified copy of BMV records, and 4 was the BMV 2255, correct?
Yes, Your Honor.
Any objection, Ms. Tomer, Mr. Torbert?
No, Your Honor.
Okay, Torbett, I apologize. Very well. States 1 through 4 is admitted without objection. Does the state rest?
Yes, Your Honor.
All right, and Ms. Tome, did the defense wish to call any witnesses or present any evidence at this time?
No, Your Honor.
Very well. Well, ladies and gentlemen, we've come to the conclusion of the evidentiary portion of our trial. The only thing left to do now will be to hear the summations of counsel, the final instructions, and then you'll begin your deliberations. It's customary for me to give the attorneys a short break before closing arguments to organize their thoughts, so as much as I don't want to take one right after another, we are going to take another brief recess. I've got about 2:52. I think 8 minutes is plenty, so let's go ahead and we'll reconvene at 3 o'clock and be prepared to deliver our closing arguments and hear final instructions. So with that, this court stands in recess. Defense has indicated a desire to make a Rule 29 motion, but I'm asking them to go ahead and hold off until the jury begins its deliberations, and I will reflect on the record that the timing of the motion, which is actually permitted at any time by the rule, should in no way, shape, or form be construed as a waiver of any of the defendant's rights. So we're ready for our closing arguments. Ms. Yeager, is the state ready to go?
Yes, Your Honor.
And who'll be delivering for the defense? And Ms. Tome, are you ready to go as well?
Yes.
All right, let's bring him in.
All rise for the jury.
All right, please be seated, and the record should reflect that the jury is now back in the courtroom. As I mentioned, ladies and gentlemen, we're now ready for our closing arguments, and as it bears the burden of proof, the state will proceed first and have an opportunity for rebuttal after the defense summation. Ms. Yeager.
Good afternoon now, and one last opportunity to thank all of you. We appreciate you being here. We appreciate your patience and your attentiveness to everybody and everything you've seen here today. Now, you've seen the video, the documents that we discussed, and the photo. You're going to have that for your deliberations to review if you need to. You heard the testimony from Trooper Capps and Trooper Casimir. Now, while you're deliberating, I want you to keep in mind, what have we talked about since the very beginning this morning when we did jury selection? And that's alcohol impacts people differently, and people exhibit impairment differently. So I want you to look at the evidence before you today. What evidence was shown and given to you? Well, the defendant initially said he had no alcohol. Didn't provide any explanation for why there was this odor of alcohol. Even the open container in the car, he said, was from 3 or 4 days ago, so that wouldn't have done it. Then later on, he admits, yeah, he had a little bit to drink. So he also exhibited many indicators that not only did he consume alcohol, but that he was impaired due to that consumption. So let's think about some of the indicators that he consumed. Red, bloodshot, glassy eyes. Okay. The odor of the alcoholic beverage that came out of the vehicle and then came off of his breath when he was outside in front of the cruiser with the troopers. The slow, slurred speech, that'll come in, and that starts to go into signs of impairment. So when you look at those two things, consumption and impairment because of that consumption. The defendant, we had testimony that he was unsteady on his feet a little bit. He swayed. He lied about having a temporary permit. He had no license and no reason to drive whatsoever. Some slow lethargic movements and diminished motor skills. And he had difficulty saying and spelling his own name. So much so that the troopers are like, hey, I tried to write it down. I wrote this down. There was this vowel, and they eventually got to the right place, but that took a while. If you're giving your name to somebody, hey, my name is Bobby, and they don't hear me, and they say, wait, what did you say? I'm going to do a couple things. Get louder and enunciate, right? Bobby, so that you can clearly hear me. I'm not going to say my name 37 different times and you still not understand it. I'm going to make an effort to make sure you understand my name. You know, the troopers did have to repeat themselves a little bit. There's some times when he seems just too impaired to understand what's exactly being asked of him. Like the alphabet test. Do you know your alphabet? He says not really. He says he dropped out in 9th grade. Okay. Well, there is no intelligence test, I should say, I guess, for field sobriety. But the alphabet test, as you heard Trooper Cap say, start with D as in David and as in X as in X-ray. So he should have started at D and said until X. That would have been the test. But he continued to say, I don't know, I dropped out in 9th grade. I don't think I really have to point it out to you that we all learned the alphabet well before 9th, 10th grade. So there's no reason you should have done that. Now, and think about the field sobriety test that was done. The HGN, the horizontal gaze nystagmus test, along with the vertical gaze nystagmus. Now, if you recall, Trooper Caps explained it's a really good indicator of impairment, and the reason for that is a person can't, control it or fake it. When you were maybe going home and you had high school or in college and you didn't want your parents to know that you were out that late or that you had alcohol and you walk in like, play sober, doing things like that. That's something you're trying to control. You're trying to control your movements and things so that nobody else sees that you may have been drunk or whatever in high school. But HGN, you can't do that. If the nystagmus is present because of alcohol, it's going to be visible to the naked eye. You heard Trooper Caps talk about it bouncing, about like windshield wipers skipping. And you'll see it on the video. Now you may have to look close. That happens a lot of times. It's hard to see somebody's eyes based on the difference in their height and where the body cam is on the trooper. But if you look, as you saw when we stopped the video at 8:15 and 8:32, you'll see the eyes doing this. That is the presence of HGN. Now remember, VGN was also present. That's the vertical when he went up. Now, if you recall, he said, you don't have vertical gaze nystagmus in every case where somebody's impaired. And that's because of what it means. And the significance of it is it's present when someone has consumed a large amount of alcohol for that particular person. If someone has a high tolerance, it might be a whole lot. Someone with a lower tolerance, it's not going to take many. But that was present here. Now, remember the effects of alcohol on the central nervous system. Remember when you're driving, you look left, you look right. If you remember back in the day, you didn't push a button to roll the window down. You had like the hand crank to roll it up and down and trying to reach across to the other side and do it. You're looking up in the rearview mirror, you're looking down at your speedometer. And if you're driving a stick, you got a whole set of other things you got to deal with. So alcohol as a CNS depressant slows reaction timing and impairs their ability to drive safely. That's why it's a problem. Now, remember, the defendant initially said he didn't have anything to drink at all. And they said, well, just a little bit. Well, he was offered the opportunity to take a breath test that would show he was not impaired. And he refused. Remember, Trooper Cap said, hey, if you test under, and I believe Trooper Casimir did too, if you test under the legal limit of .08, there is no license suspension. It's only if you test over or you refuse that one comes into play. So while the HGN is a great indicator of impairment, if you only consider the chemical test, it's the one definitive test that would have cleared him. It's the one definitive test that would have said he had nothing to drink or he had just a little bit and wasn't impaired. Now, one very key thing I want to keep you all to keep in mind is what do you think is a very big clue of impairment, and was it present here? If you're questioning it, look at the driving. Okay? We heard he was driving really fast. We heard he was fast approaching a semi and had to slam abruptly on his brakes in order to stop and not hit that semi. That he was slow to pull over. And you saw in the video, he was slow to pull over, and it took him a while to get the whole car across the white fog line. His girlfriend, his 18-year-old girlfriend was in the car. Yeah, they had an emotional day. Just found out she was pregnant. They were going to have a baby. Great. I think that actually goes further to show he's impaired because of the poor judgment he displayed by driving her car at 127 miles an hour down I-70, almost hitting a semi, with his pregnant girlfriend in the car. He ignored any potential risk that could have came from that behavior. He wasn't wearing a seatbelt. If he would have hit that semi, think about what could have happened. So, taking everything else aside, again, look at the driving. Only an impaired person would drive 127 miles down the freeway with their pregnant girlfriend in the car. So I ask that you use your common sense during your deliberations. You heard and saw the defendant on the video. He ultimately did not do the one test, the breath test, and he was given 2 opportunities to say yes to that. That would have proven he was not over the legal limit. It's the one test that would show, yeah, he's not impaired. He's just emotional. So if you use your common sense and look at all those factors, you will find that the state has proven its case beyond a reasonable doubt and returned a guilty verdict on the OVI charge. Thank you again for your service.
All right, Ms. Tone?
Thank you, Your Honor. Good afternoon. Again, thank you for being here. I know we've been thanked multiple times, so you're obviously a crucial part of this system, and we thank you for being willing to listen to this case and consider this case on behalf of Mr. McCoy. Okay, so what did we learn during this presentation of evidence? We learned that we have a 21-year-old young man who learns his girlfriend is pregnant, and they are having an emotional day, and they are crying, and he has a 9th grade education, and he has no driver's license, and he's driving way too fast. That is pretty much what we learned during the presentation of the evidence, and we don't dispute any of that. But none of that is why we're here. None of that has anything to do with the decision that you have to make. You have to determine whether or not Trent was under the influence. We know he was operating, and we acknowledge that he was speeding, excessively speeding, and he shouldn't have been. And for that, that's a decision that's going to be made by the court to determine, what punishment he would get, whether or not he's guilty of that. That's not for you to decide, but we're just flat out saying, yeah, he screwed up. He should never have been driving that fast. He should have never been driving without a license. Absolutely. But was he under the influence while he was driving? You're going to hear the judge is going to provide you the definitions of all of the elements of the offense. Under the influence, I'll just give you a little preview, says that it has to impair the defendant's actions, reactions, or mental processes, deprive him of clearness of intellect and control of himself, which he would have otherwise possessed, and the consumption of alcohol has to so affect the nervous system, brain, or muscles of the defendant so as to impair, to a noticeable degree, his ability to operate a vehicle. Then he's under the influence. Okay, we don't have any of those things here. And I know the state is trying to tell you, yes, we do. And the troopers are trying to tell you, yes, we do. But you can they can be wrong, first of all. We know that they all think he's guilty. That's up to you to decide whether or not he's guilty. And again, with that really high burden that we'll talk about again as well. So how was his nervous system, brain, or muscles impaired to a noticeable degree that impaired his ability to operate a vehicle? He's speeding. He didn't do anything else. They like to talk about how incredibly dangerous that was. Okay, but he didn't have an accident. He didn't hit the semi in front of him. He shouldn't have been driving so fast, but he didn't. In fact, he said, there's a greater risk that those things are going to happen based on your speed, and they didn't happen here. So it's actually the opposite of evidence of impairment. It's evidence that he's driving really fast, it could have been really bad, and it wasn't. And why not? Because he's not impaired. There was no evidence that his driving was impaired. There was evidence that his driving was really fast. The state has sort of a damned if you do, damned if you don't approach, I believe, here. He stopped too fast when he got close to the semi. He stopped too slow when he was going to be pulled over. The cards are kind of stacked against him here. He can't do anything right. Well, I'll submit to you that he did. He did a lot of things right. He is able to pull over, put on his hazards, engage in a conversation with the trooper, no license, knows he's going too fast. Yeah, he's like super nervous and maybe doesn't come across the greatest. But again, keep in mind what I said. He's 21, he's got a 9th grade education, and he's screwed up because he's not even supposed to be driving. So there's a lot of nervousness, emotion. You know, as we said, both of them confirmed that he had been crying. But does that mean he's under the influence? Troopers are able, they want to talk a lot about slurring his words, but they're able to understand him. There was a problem in the spelling of his name, but we talked about that, and maybe we talked about it too much. I mean, his name is unusually spelled. It's not O-N, it's E-N, T-R-E-N-T-E-N. So they want to characterize that as slurring. But again, they don't know him. That's just how he talks. That's how he spells his name. We see him, and they have to acknowledge the things he does right. He appropriately gets out of his vehicle. He engages in the discussion with him, with both troopers, while they're administering the HGN. He's like this. I mean, they talk about swaying. I don't know. You can form your own opinion on if you see swaying in there. But he's definitely standing there like this, and he's, yes, sir, yes, sir. They indicate, oh, yeah, there's definitely evidence of impairment there. But take a good hard look at that and think, is that somebody that you think is under the influence? So what does he do next? He doesn't want to do the walk and turn. Acknowledges, he's got some knee problems. They ask him about it. He tells them. He appropriately answers their questions, all the medical questions. Ultimately, they just decide to arrest him. And then, obviously, he has some, he's like, oh, I'll try to walk the line. I'll try to walk the line. This is a young man that is able to engage with these officers throughout this encounter, and, they're able to understand him. They're able to have a discussion with him. This is not somebody that is certainly not falling down drunk. Everybody acknowledges that. And I know the troopers are going to say, well, you don't have to be falling down drunk to be under the influence. But I'm sorry, I just, I don't believe it exists in this case. I don't believe that we are looking at somebody who is been proven beyond a reasonable doubt to have been operating that vehicle while impaired. I want to talk a little bit more about proof beyond a reasonable doubt. We're talking about Macy and the potential cancer diagnosis. Remember that? These are things, this is the most important of your own affairs. Again, this is the most important of Trent's own affairs. And you have to hold the state to this burden of proof. You have to be looking for evidence, not evidence of speeding, not evidence of not having license, not evidence of being confused and maybe not knowing your alphabet. Maybe those things are, they're a problem in their own right, but they're not under the influence. So, most important of his own affairs, proof of such character that you're willing to rely and act upon it, that he's driving under the influence. That the state has shown you that he is under the influence of alcohol, such that he should not have been operating that vehicle because of impairment by alcohol. That they have proven that to you beyond a reasonable doubt. Proof of such character that you'll rely and act upon it in the most important of your own affairs. Again, this case is about a lot of things, but when it comes to operating that vehicle while impaired, it's not there. There's not anything here that you can rely on that is like you would rely on in the most important of your own affairs. They just haven't met their burden. This is just not that case. This is, again, a case about a lot of things, but it's not driving under the influence. Now, the state's going to have an opportunity to stand up when I'm done and, talk more about why he was, and that's because, they have the burden of proof, and that's okay. So this is my last. The last time you're going to hear from us. But I do want you to please keep that in mind, that there was a lot going on here, but it's not evidence that you're going to rely on that somebody was operating a vehicle while impaired by alcohol. Thank you.
All right, Ms. Shaker, your rebuttal.
Ms. Tome talked a lot about what does under the influence mean. And she said, hey, the state is trying to prove to you, yes, we agree on that. That is exactly what I am doing. That is what we're here to do. So let's talk about this under the influence definition that she read you. And did the consumption so affect the nervous system, brain, or muscles of the defendant so as to impair to a noticeable degree his ability to operate the vehicle? Well, let's talk about that. Because you did hear a lot of things today, but it's not any one of those things saying, yep, he was under the influence because of that one item. It's all of these things together. So I already talked about like the HGN, the odor, and all that, but hey, let's take some of these things in turn. So like the nervous system and muscles. What was affected? Well, when he did stop, he was slow to pull over and stop. That's a delayed reaction. That's a depression of the nervous system. He was slurring. There was never any discussion that mentioned that they could not understand him at all. There was the confusion about his name, but they could, yes, have a discussion, which is good, because if not, then he probably would have needed to go to a hospital. He was unsteady on his feet. That's an effect that alcohol can have on the nervous system and your muscles. He fell asleep in the cruiser a couple times. He even took off his seatbelt. That'd be an effect on the nervous system and potentially the brain. Speaking of the brain, what was impaired there? His judgment. No license, no seatbelt. Driving his pregnant girlfriend's vehicle at 127 miles an hour. And then he lied. Twice. Not 3 times, but twice. About 2 things. First, he says he has temps, but he didn't. At that time, he had no license, no temporary permit, but he just said, oh, I have a temporary permit, it's just not on me. Didn't have it at all. The BMV records will show you that. Then he lied about his alcohol consumption. Didn't have any, well, just a little bit. Well, central nervous system depressants such as alcohol can impair your judgment in your brain activities where you do lie about things. The alphabet. He said he didn't know it, dropped out in 9th grade, didn't know it. Well, when he was getting arrested, right before they placed him under arrest, he says, what, you mean like A, B, C, D, E, F? And he starts reciting it. Well, so he obviously knows the alphabet. He's just too impaired to understand what's going on. Lastly, again with your common sense. We talked earlier about how alcohol affects people. You all know when someone is impaired. Guess what? Police officers do too. The difference is they have additional specialized training and certification to detect drivers under the influence. So just like you, they know when someone is impaired. They just have additional stuff that they get to get up here and talk about. And remember, the driving is often a big key indicator of impairment. And he was going 127 miles an hour. We ask that you return a finding of guilt on the OVI offense, and we thank you again for your time.
Well, ladies and gentlemen of the jury, you've heard the evidence and the arguments of counsel. The court and the jury have separate functions. You decide the disputed facts, and the court provides instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law or to apply your own conception of what the law should be. You'll each be provided a written copy of these instructions to have with you during your deliberations, so please do not concern yourself with trying to memorize what I'm telling you now. A criminal case begins with the filing of a complaint. A complaint informs the defendant that he has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charge and puts at issue all the essential elements of the offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be found not guilty unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the complaint. Reasonable doubt is present when, after you've carefully considered and compared all the evidence, you cannot say that you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence is the testimony received from the witnesses and the exhibits that were introduced during the trial. Evidence may be direct, circumstantial, or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he testifies. This includes any exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of humankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of fact which you may, but are not required to make, from other facts which you find have been established by direct evidence. Whether or not an inference is made rests entirely with you. Direct and circumstantial evidence are of equal weight. The evidence does not include the complaint, opening statements, and closing arguments of counsel. The opening statements and closing arguments are designed to assist you. They are not evidence. Answers of witnesses and statements of counsel that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not speculate as to why the court sustained an objection to any question or what the answer to such question might have been. You must draw no inference or speculate on the truth of any suggestion included in a question that was not answered. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will apply the tests of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand, his manner of testifying, the reasonableness of the testimony, the opportunity he had to see, hear, and know the things testified to, his accuracy of memory, frankness or lack of it, intelligence, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because he was placed under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that he did not testify must not be considered by you for any purpose in determining whether the state has proven its case beyond a reasonable doubt. The defendant is charged with operating a vehicle while under the influence of alcohol. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 7th day of March in the year 2024 in Lincoln County, Ohio, the defendant operated a vehicle while under the influence of alcohol. Now, there's been a lot of talk of essential elements. I'm going to define those for you now. Operate. The term operate means a person must cause or have caused movement of the motor vehicle. Vehicle. Vehicle means every device, including a motorized bicycle, in, upon, or by which any person or property may be transported or drawn upon a highway, except that vehicle does not include any motorized wheelchair, any electric personal assistive mobility device, Any device that is moved by power collected from overhead electric trolley wires, or that is used exclusively upon stationary rails or tracks, or any device, other than a bicycle, that is moved by human power. Alcohol. Alcohol means ethyl alcohol, whether rectified or diluted with water or not, whatever its origin may be, and includes synthetic ethyl alcohol. Alcohol does not include denatured alcohol and wood alcohol. Under the influence. Under the influence means that the defendant consumed some alcohol, whether mild or potent, in such a quantity, whether small or great, that it adversely affected and noticeably impaired the defendant's actions, reaction, and mental processes under the circumstances then existing, and deprived the defendant of that clearness of intellect and control of himself which he would otherwise have possessed. The question is not how much alcohol would affect an ordinary person. The question is what effect did any alcohol consumed by the defendant have on him at the time and place involved. If the consumption of alcohol so affected the nervous system, brain, or muscles of the defendant so as to impair to a noticeable degree his ability to operate the vehicle, then the defendant was under the influence. Evidence has been introduced indicating that the defendant was asked but refused to submit to a chemical test of his blood, serum, breath, or urine to determine the amount of alcohol in his system for the purpose of suggesting that the defendant believed he was under the influence of alcohol. If you find the defendant refused to submit to such test, you may, but are not required, to consider this evidence along with all the other facts and circumstances and evidence in deciding whether the defendant was under the influence of alcohol. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of operating a vehicle while under the influence, your verdict must be guilty, according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of operating a vehicle while under the influence, then your verdict must be not guilty, according to your findings. Your initial conduct upon entering the jury room is a matter of importance. The first thing you should do is to elect a foreperson by simple majority vote. The foreperson will see to it that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. It is not wise to immediately express a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide that you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest beliefs in order to be congenial or to reach a verdict solely because of the opinion of other jurors. You may not discuss or consider the subject of punishment. In the event that you find the defendant guilty, the duty to determine the punishment is placed by law on the court. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence, and make your findings with intelligence and impartiality, and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that the case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view on the facts, you are specifically instructed to disregard it. If, during your deliberations, you have a question for the court, it should be discussed in the privacy of the jury room. It should be reduced to writing so that there will be no misunderstanding as to what you request. It should not reflect the status of your deliberations. It should then be delivered to the bailiff by ringing the bell, and she will submit it to the court. If the court can answer your question, you will receive an answer in writing. If the court cannot answer your question, you will be advised of that as well. You may not request a transcript or a summary of any witness's testimony. You must rely on your collective memory as to what each witness testified to during the trial. Now, you'll have with you in the jury room the following verdict forms. And there's only one charge that you're going to be deciding, so there's only one set of verdict forms. They're both identical in almost every way, with the name of the defendant, the case number, the charge. Only one, and don't read anything into the order that I'm reading these, but one simply says, "We, the jury in the case, find the defendant, Trenton W. McCoy, guilty of the offense charged in the complaint." The other says, "We, the jury in this case, find the defendant, Trenton W. McCoy, not guilty of the offense charged in the complaint." When you've reached a verdict, you'll complete the form that corresponds to your decision and sign that verdict form in ink. Now, the foreperson will sign the appropriate verdict form twice, once in the capacity of foreperson in the space indicated, and once as a juror on one of the 8 lines provided. The foreperson only gets one vote, but must reflect his or her specialized status by virtue of the second signature on the foreperson's line. The court will place in your possession the exhibits, the verdict forms, and the exhibits, with the exception of the videos on the flash drive. If the jury wishes to view any of the videos during deliberations, ring the bell, and Bailiff Kyle will assist you in doing so. The foreperson will retain possession of these items, including the verdict, and return them to the courtroom at the conclusion of your deliberations. And you should place your verdict forms, both of them, as well as the exhibits, in the manila envelope here. Now, until your verdict is announced in open court, you're not to disclose to anyone else the status of your deliberations or the nature of your verdict. At this time, I'm going to ask counsel to approach and inspect the verdict forms. All right. Does either counsel have any objections or additions to the jury instructions or the verdict forms? Ms. Yeager?
No, Your Honor.
Ms. Tome?
No, Your Honor.
All right. Mr. Higgins, you were selected to serve as the alternate juror in the event of any misfortune or an illness to a member of our jury. Now, you're still instructed not to discuss this case or tell anyone how you would have voted until the jury has returned a verdict, but you'll be excused in a moment, and if you have any belongings still in the jury room, you may retrieve them at the conclusion of the jury instructions. You are free to remain and await the verdict, or you can leave if you wish, but please stick around until I've had an opportunity to speak with you, and just have a seat on the front bench over there. Now, for the remaining members of the jury, after you retire to the jury room, and whenever all 8, and I repeat, all 8 jurors unanimously agree on a verdict, you'll sign the appropriate verdict form in ink and advise the bailiff by ringing the bell, at which time you'll be returned to the courtroom. So at this time, Ms. Kyle, will you please escort the jury to the jury room?
All rise.
All right, well, please be seated. And the record should reflect that the jury is now back in the courtroom. All 8 members of the jury are seated in the jury box. Juror number 1, it's my understanding that you were elected foreperson? Yes, sir. And has the jury reached a unanimous verdict? We have, Your Honor. All right, please provide the envelope containing the verdict forms to Ms. Kyle. Thank you. All right, in the case of the State of Ohio versus Trenton W. McCoy, 24 TRC 01956, on the offense of OVI in violation of Revised Code Section 451119A1A. The verdict reads as follows. We, the jury in this case, find the defendant, Trenton W. McCoy, guilty of the offense charged in the complaint. It appears to be signed by all 8 jurors and then a second time by the foreperson in the appropriate space. Ms. Tome, did the defendant wish to poll the jury?
Yes, Your Honor.
Very well. Ladies and gentlemen, I'm going to ask you a simple yes or no question, and please respond accordingly. Juror number 1, is this your true and accurate verdict? And juror number 2, is this your true and accurate verdict? Yes, it is. Juror number 3, is this your true and accurate verdict?
Yes.
Juror number 4, is this your true and accurate verdict?
Yes.
Juror number 5, is this your true and accurate verdict?
Yes.
Juror number 6, is this your true and accurate verdict? Juror number 7, is this your true and accurate verdict?
Yes.
And juror number 8, is this your true and accurate verdict?
Yes.
Is the defense satisfied?
Yes, Your Honor.
Very well. At this time, I'm going to excuse the jury into the jury room, come back and brief you, and quickly, but we will come back out and proceed to sentencing on the charges. Incidentally, the court is going to go ahead and enter guilty findings on the no operator's license, seatbelt, and reckless operation charges. That being said, let's go ahead and stand in recess.
All rise.
Care to make a statement in mitigation on his behalf?
Judge, I just recalled back to my pretrial notes. I think because of he has no prior record, it's a first offense, but there was some concern maybe with the high rate of speed, and the court indicated that you may be interested in suspending additional jail days, but I would ask the court to impose otherwise first offense mandatory minimum penalties. He's also on probation out of Franklin County. His attorney on that case is present and can speak to any.
My notes indicate that he's actually participating in a specialized docket program.
Yeah, Judge,
Yes.
he's a member of Judge DeVarga's Unleashing Potential program. It's a diversion court for young people like Trenton. So the goal is, instead of the ordinary terms of probation, to kind of put him in a better spot with jobs, housing. A driver's license is definitely on the list for him. Maybe some safe driving courses, things like that, to put him in a better spot to, drive out the recidivism factors in this. So he will be actively involved in that, and I'm due to talk to Judge DeVarga about his situation in the next week or 2.
Will this conviction have any impact on his participation in the specialized docket?
The conviction is not going to get him terminated from the program, if that's the court's concern.
All right. Anything further from defense counsel?
No, Your Honor.
Mr. McCoy, you have a right to address the court before sentence is imposed, although you're not required to. Is there anything you want to say here?
No, sir.
Ms. Yeager, did the state wish to be heard regarding the matter of sentencing?
Yes, Your Honor. In hearing Ms. Tome discuss pretrial notes, I believe that is what I have here. However, I would ask the court to reconsider and possibly impose just a few extra jail days, like a week total instead of just the minimum 3. Simply because of how egregious Mr. McCoy's conduct was and how dangerous it was for him, his pregnant girlfriend, and everybody that was on the roadway that day. I think what happened here was at a level that's a little more severe than, kind of like a standard run-of-the-mill OVI, where he's going almost double a freeway speed limit. I find that really problematic, and he almost hit a semi, was weaving. So we would ask the court to impose 7 actual jail days, but otherwise mandatory minimums as far as the fine and so forth.
All right, thank you. Well, let me start off by saying I don't find the state's request or recommendation to be unreasonable or unwarranted. It's obviously, when we talk at pretrials about, hey, okay, is this a first-time offender, or is there any aggravating circumstances here? This is pretty aggravated. I don't disagree with that. I was appalled when I saw that narrative report indicating how fast the defendant was going, and I wasn't aware until the testimony today that the defendant made, and his girlfriend made, the monumentally stupid decision for her not to drive. She was a perfectly valid licensed driver. She was sitting right next to him. If she was impaired, then these troopers weren't doing their job, and those troopers did their job. So what thought process went into, I'm going to drive? The only thing I can think of is that the defendant insisted upon it, and then it would be nice to have had a camera inside of that vehicle, because I firmly believe, and would probably bet my next 10 paychecks, that she was screaming at the defendant to slow down. You almost cut short your life, the life of your girlfriend, the life of your unborn child, and the lives of anybody else who might have been out there. It's completely inexcusable and frankly unforgivable at this point. It was serious enough that Judge George actually put a cash or surety bond on a first-time OVI offender in order for the defendant to be released. Now, the other thing is, I always say that the court strives to be consistent with what its pretrial communications are, because it's not fair to change the game. I was talking to the jurors actually about the concept of trial tax or rent on the courtroom, which obviously this court does not believe in. And usually I reserve changing what I say I would do, and if there's something new that comes out at the trial the court was not aware of at the time of the pretrial. That's not the case here, and although I, as I said, find the state's request to be reasonable and warranted, I'm going to go ahead and deny that simply because I intend to be consistent with what I said. However, what I did also say was because of that, I was going to suspend additional time than I normally would. So, on the OVI charge, it'll be a 90-day jail term. 87 of those days will be suspended. The defendant will be on probation for 1 year. He'll be prohibited from consuming any alcohol, using any illegal drugs, or abusing any prescription medication. I'll leave the use of a scram device up to the discretion of the probation department. Although at this point he's he's going to be 23 this year, I think.
Yes, sir.
Yeah. But does he have an abstinence order out of the specialized docket?
I'm sorry?
Does he have an abstinence order out of the specialized docket?
No.
Okay.
Well, I mean, in theory, but it's not something we're actively tracking right now.
Right. He will be required to do the 3-day program instead of the jail time. He needs to maintain suitable employment. Follow department sets. The fine will be $375. Cost will be assessed. The court will go ahead and impose a 2-year license suspension effective from the day before he does. On the remaining charges that were tried to the court, on the driver's license offense, that'll be a $150 fine. On the seatbelt violation, it'll be a $30 fine. And if it wasn't for the fact that this reckless operation was a minor misdemeanor, the fine would be considerably higher, but I'll impose a maximum fine on that charge of $150. Now, Mr. McCoy, you have the right to appeal the verdict in this case, as well as the sentence that I've imposed. You have a right to have a notice of appeal filed on your behalf within 30 days of today's date. You have a right to obtain a transcript of the trial, which is required to pursue an appeal. And furthermore, you have a right to be represented by counsel. If you qualified as indigent, which you did in this particular at the trial court level, not only would you be eligible to have an attorney appointed to represent you for the appeal at no cost, you would also be eligible to ask the court to seal to provide the transcript at the public expense. any idea or discussion yet whether or not the defendant intends to take this up?
We have discussed it, Your Honor.
Very well. So, Mr. McCoy, you know, you need to thank your lucky stars. I think in many other courts of this state or across this country, you'd be leaving this courtroom in handcuffs, and deservedly so. But, you know, you're engaged over in Franklin County. There's going to be adequate supervision here. It'll be a tight leash, you know, and maybe what Franklin County isn't bothered by, Licking County will be. So you need to be 100% compliant with these terms, and your failure to do so will result in you serving the entire balance of the suspended sentence. Do you understand that?
Yes, sir.
Mr. or Ms. Tome, anything further?
He does have, he was taken to jail, Your Honor. Looks like, I don't know if it's 1 day or 2 days.
Well, it's probably none, because he actually was arraigned later that day after his arrest, and he posted bond. Let me see when he posted bond.
Yeah, of an incident and an arraignment date of 3/7.
Right.
I see
He
bond-
posted
says
bond on the
posted.
same day that he was both arrested, charged, and arraigned. So, court,
Okay, maybe it just wasn't updated. Court view shows bond posted on 3/8. And
Uh,
arrest
well-
was on 3/7.
3/7 of 2024 was a,
That was the Thursday.
it was a Thursday, so I don't know why it was
Okay.
reflected on the
Okay.
8th, because
If
that
it's-
was, or no, March the 7th was a Friday. No, that's this year. March the 7th was a Thursday. I don't know why it would say the 8th, because he was arrested and in jail early enough on the day that they would have added him to the arraignment list that day, as they did, and Judge George conveniently wrote down the date of his arraignment. So,
Well, I think he got the bond on the 7th, but he didn't post it till the 8th, is what Ms. Tome was
Yes.
indicating.
well, here's what it says on the bond. It says, on date posted on page 2 of the bond, it says 3/7/2024. It's file stamped March the 8th, but it's clear that he was released the same day, so I'm not going to give him
okay.
any credit. If you can show me evidence to the contrary, I'll give him whatever he's entitled to, but I don't believe that he's
Okay.
entitled to any credit.
Okay.
All right, that being said, anything else on behalf of the defendant, Ms. Tome?
No, Your Honor.
Anything else on behalf of the state, Ms. Yeager?
No, Your Honor.
All right, very well. You may go with the bailiff. This court stands adjourned.